Welcome to the January 24th, 2025 episode of the Energy Show. I'm energy journalist Markham Hislop. Today I'm going to be joined by lawyer and researcher Drew Yewchuk, who I've interviewed many times, and we're going to be talking about the January 17th charges, 9 of them, leveled against the Imperial Oil by the Alberta Energy Regulator relating to some incidents that took place in 2022 and 2023. Energy Media has covered this extensively. You can go back and look in our podcasts and news stories. And it is, I think, a very serious issue. And so we'll chat with Drew about that. Welcome to the Energy Show, Drew.
Nice to talk to you again.
Well, hey, I mean, this is our new format, and the first time for you on it. We appreciate it. But this is a newsy story. This is a really important one. It took place a week ago, but nevertheless, give us a little bit of a rundown on what the issue is here.
Sure. So this is the Alberta Energy Regulator enforcing against Imperial Oil for issues at the Kearl oil sands mine. There's at least three different different kind of contraventions here that are worth mentioning. The first one was the shallow seepage that took place in 2022 and 2023. For that, the Alberta Energy Regulator gave administrative penalties earlier in August 2024. That was $50,000. It was kind of embarrassingly small. They were roundly criticized. The second contravention is the one that these charges deal with, which is the overflow of a wastewater pond. Those two things are physically connected. The reason the wastewater pond probably filled up so fast connects to the amount of shallow seepage, but a device that was supposed to detect the wastewater filling up the pond did not work right, and it totally overflowed. Part of the berm washed out, and it went off lease onto public land. So that's the issue we're dealing with here. The third one is still not addressed, and that is the deep level seepage. Deep meaning physically lower in the groundwater, so it's potentially going further directly into the rivers. That one has been going on for who knows how long. It's sort of an open secret that that's a problem with tailings. We don't see any enforcement yet or action on that.
Yeah, this is an issue. I did actually a lot of work with Dr. Bill Donahue and Mandy Olsgaard, a former senior toxicologist at the AER. And thanks to them, I went back and I actually read the annual groundwater studies that Imperial Oil was doing. And what's very clear is that and we should point out that these big tailings ponds are designed to leak. There's so much pressure in there that you just can't contain it. You need to relieve it by letting it leak, but then you capture it with a recovery system and pump it back into the tailings pond. That's the theory. The problem here is that there is fluid leaking out somewhere in the bottom of the tailings pond, getting out past the interception system, and then there are monitoring wells that are supposed to be picking this up. And they did pick them up, but the studies show very clearly rising levels of chemicals, some of them very problematic, in increasing intensities further and further and further from the tailings pond. And the question then becomes, at what point should the Imperial Oil intervene? Because the decision was made to monitor only, not to intervene, but to monitor. Mandy, for example, says that, oh, no, it was Bill who made the point. He said, that's an early warning system. And they should have intervened based on the data that they were seeing. They didn't. And that would seem to be cause for some kind of administrative penalty or criminal charge by the AER. And any idea why that's not happening?
So I think the reason the AER is willing to deal with the first two issues I described is because they're physically and time bounded. Like they know who it was. It was Kearl. You can point it out on a map. The deep groundwater seepage is not just Kearl. It's every oil sands tailing pit. when they decided to allow oil sands companies to build tailings pits that don't have any kind of plastic or concrete liner on the bottom of them, they knew or should have known that they would eventually deal with a huge seepage into deep groundwater problem. So for that issue, the AER isn't just dealing with curl, and they're not dealing with one small wastewater pit. They're dealing with how do we deal with it? We didn't regulate the whole industry right. And so I can understand why they're much more concerned about how they're going to touch that one. So we haven't seen anything there.
Yeah, that's very interesting. Now, there, I would argue that there's actually a fourth issue here, and you do raise it in your a blog post, and that is the issue of when people were informed.
Yes.
So the public was not informed, and this is the really good, important one, I think, is that local indigenous communities were not informed. And leaders like Chief Alan Adam of the Athabasca Chippewa First Nation were outraged. And, Curl and Lori Pusher, the CEO of the AER, were dragged up in front of the House of Commons Environmental Committee. I mean, this was a big, big issue over the last year and a half, let's say. And so and also FOIP requests that you put in that have never been answered or not answered adequately. So is that a fifth issue? Maybe.
Yes, that one's still live. That one's not that maybe was the AER's mistake or responsibility, but that's not their investigation. That's the Office of the Information and Privacy Commissioner looking into the actions of the Alberta Energy Regulator. So that is still, as far as I know, live. We're not guaranteed to get any public report from them. Haven't heard anything from them yet. I do think they'll at least say when they close the investigation or give some summary of their result. So yes, that's another issue. That one's still going on.
And before we get into the actual charges and how that all works, which we'll do in a moment, I want to point out that viewers can go and listen to Dr. Kevin Timoney on my Energy Talks podcast, episode 413. I think it was published January 6th. He published a study titled AER's, no, sorry, this is my title on the podcast, but I think there's a link in the show notes to his actual paper. But the title is my title headline is AER's outrageous oil sands spill reporting errors subject to a new paper. The point here is Timoney is a dog with a bone. I mean, he has meticulously gone through tens of thousands of company and AER reports. They're reporting and found numerous discrepancies and errors and lack of information. And it's talking to him, it's a mess. It's an utter mess. And yet the public facing comments from both the AER and the company are, don't worry about it. We're giving you all the data. We're giving you all the information. We've got it under control. And when you pull back the curtains a little bit, it doesn't look like that at all.
Yes, there's an attempt by the AER, and I've said this many times before, so I'll repeat myself very shortly, to to exaggerate how much data they capture, how effective they are at knowing what's going on, and how effectively they protect the environment. I think one implication of Timoney's findings, which are still shocking to me after knowing what a mess things are, uh, is that the AER is taking a similar approach to the oil sands that they did to early and I guess continuing oil and gas development, that any spills that occur on lease, they don't really care about because they've decided, well, one day we'll make the company clean up the whole lease anyway, so whatever they spill into the ground now is not a big deal. And that's not right. That what spills into the ground on the lease is seeping off of the lease. So yeah, the AER is making a mistake there, and it's a mistake they've made before.
There's two facets to this issue. There's the immediate one where the leaks aren't cleaned up and then they seep off the lease. Then there's the other one of cleanup, because we've discussed this many times. And again, for background, I interviewed Drew extensively for my unethical oil part two, where we talk about conventional oil. And there, the heart of the problem with reclamation of oil and gas wells in Alberta is that the government chose almost 100 years ago not to take security at the beginning of the well, the start of the life of the well. They decided to impose cleanup at the end of the well's life when there's no more money left, and companies don't want to spend money on an asset that is generating no revenue for them. And so there's a huge problem in Alberta with, tens of thousands of these wells sitting in the inactive category, and they've applied the same principles in the design of the oil sands liability management system. So there's supposed to be billions of dollars set aside, and there's only $1 billion for cleaning up. I don't know how many, is there 30, 37 tailings ponds? It's a fraction of what's required for an enormously large problem.
Yeah, yeah. I really I've got very little to add to that description of it. Yeah, they have not they after reviewing the mine financial security program the other year, they did not fix it. It's still totally broken.
Okay. Amongst all of these issues, now there are these charges that have been laid against. Maybe you can give us a description of them.
Sure. So the AER laid 9 charges under the Environmental Protection Act and the Public Lands Act. The first point that I think some news outlets had trouble with is that both the Environmental Protection Act and the Public Lands Act use a system of what could be called sort of criminal charges. They're sort of regulatory offenses or administrative penalties. And administrative penalties are more like a parking ticket or a speeding ticket style of procedure as compared to like a drunk driving charge. So on one, you're kind of getting a ticket, you maybe send some letters back and forth with the regulator, and then you pay your fine. On the other one, you're actually going to court. You're going to show up before a judge, you're going to have to enter a plea, you're getting a much larger procedure. And the greater procedure is attached to a risk of much higher penalties. So even though there were potentially very large penalties for the administrative regulation, the administrative penalties in the previous instance, because of how long that seepage went on, there's more possibly at stake for Imperial here. There's a rule named for a case, so it's called the Kine-Apple rule, but the name's not important unless you're a lawyer, that penalties aren't applied for a charge that has the same basic facts underlying it. So 2 of the charges are 1 count for failing as soon as they became aware or ought to have become aware of the release to take all reasonable measures to repair, remedy, and confine the effects of the substance. The other is 1 count for failing as soon as they became aware or ought to have become aware of the release to take all reasonable measures to remediate, manage, remove, or otherwise dispose of the substance in such a manner as to prevent an adverse effect or further adverse effect. That's legalese. Those are describing pretty similar events. So even though there are 9 charges, some of them might duplicate each other, and Imperial will argue we can't face different penalties for the same action described in 2 different ways.
If I can just interrupt, does that mean there's a chance that they will not face penalties under the criminal charges for the event for which they received the administrative penalty?
No, because the administrative penalty related to the shallow seepage issue. This one relates to the overflow of that tailings wastewater area. The difference between wastewater and tailings is not even consistent. So wastewater is how it's being described, and I'm going to call it that too. It's also kind of tailings, but that's not an issue. But despite the number of 9 charges, whether it's really 9 or it's 4 or 5 or 6 is not totally clear. But the maximum daily penalty for administrative penalties in the parking ticket style system is $5,000, subject to a bunch of variances and rules that can make it much lower or higher. The potential penalties on the criminal route are a lot higher. They're for these charges, I think $500,000 a day or $1 million a day. So depending on how much the AER is going to seek and how much they're going to argue along with as through the prosecution, that Imperial should pay, Imperial has a lot more at stake.
So, describe for me the role that the AER plays here. Do they lay the charges? Do they act as an advisor to the prosecutor? Does the judge finally determine what the amount of the penalty is?
They Their relationship to the prosecutor is not completely obvious because the prosecutor does not become their lawyer. Technically, the prosecutor has their own prosecutorial discretion, but the AER is working with the prosecutor, I guess, in the role of sort of an expert. So they'll be advising the prosecutor, not advising, they'll be communicating with the prosecutor about what they think the final penalties should be. The prosecutor will make those decisions and argue them before the judge. The judge makes the final choice on penalties. It's very unusual for a judge to say a prosecutor has gone too low and that they're going to impose something more than what the prosecution has asked for. What could also happen is that uh, if there's a conviction, the prosecution and the AER together will negotiate with Imperial for a final penalty. And that is what happened in the previous Syncrude Ducks case that ran from 2008 to 2010. The final monetary amount, the 3 million penalty, was negotiated as sort of a plea bargain for a penalty and put before a judge, and then the judge approved it. But the next step will be Imperial making a court appearance in late February. I think it's the 26th. February 26th. And then they'll seek an adjournment or they'll enter a plea, so they'll plead guilty or not guilty.
What's the upper boundaries of the potential penalty the judge could impose on Imperial?
So I thought about that question a little bit and I wrote about it in the blog. It is somewhere over 3 million, but I'm not sure if the AER is going to seek the maximum penalty. It would be a little unusual for a prosecutor to just calculate what's the absolute maximum allowed by law, and I'm going to seek it. So they'll probably seek what's most important is what the AER thinks is the just penalty in this case, and they have sort of implied they're not going to tell people until later in the process, possibly until either after there's a guilty plea or a conviction.
I have to say, Drew, looking at this as a layman, and I would imagine many Albertans will feel the same, is that for a company that I forget what Imperial Oil's revenue was last year, but whatever it was, $3 million is, pretty much the coffee fund for headquarters in any given year. And it seems like it's insignificant. Where is the actual pain, the penalty, what is it that is really the motivation for them to change their operation so that this doesn't happen again? Because frankly, $3 million, it doesn't seem to me to be that it's going to do it.
That might be an argument that there should be higher penalties under the Public Lands Act and the Environmental Protection Enhancement Act. One reason that sort of weird discrepancy might exist is that those two laws were built for what you would think of as more normal-sized projects. And because the oil sands are these titanic, mega projects, that the penalties come in at a strangely low amount. There's options to give creative environmental sentences to Imperial and require the money to be put towards particular things that change the way the oil sands are regulated. That's the real possibility for the AER to change the way it regulates the oil sands and regulates tailings to try to stop this kind of stuff from happening. But changes to regulations won't come through the criminal process or the criminal regulatory penalty, administrative penalty. It's not through the penalty process. That's coming through regulatory decision making and is kind of separate from the penalties they give Imperial. This is a backwards looking process for the most part, not looking forwards at changes to how the tailings are regulated.
Yeah, and I don't see any real pressure. Well, that's actually not true. The indigenous communities in northern Alberta are really upset about this, and Chief Adam has called for the AER to be disbanded and a new regulator created that includes indigenous communities, the province, and the federal government. And they're so. But that's an important voice, but it's in Alberta, it's not a huge voice. It's not an incredible, not an overly influential voice. I don't hear any other voices calling for reform of the regulations to prevent incidents like this happening again.
Uh, well, it's those First Nation communities and it's the environmental community has, of course, been pretty interested in trying to get the tailings ponds and the oil sands to stop trashing the northern half of the province. But I would agree at the moment those aren't groups that have a huge amount of influence with uh, the current Alberta government. They just don't have the money.
Yeah, and that's really what this comes down to, it would appear. And we should also point out that the Alberta Energy Regulator, I've interviewed other experts about this, and the AER is kind of held up as a classic captured regulator, one that confuses its public-ish interest mandate with the industry's interest. And over time, you could almost argue from the beginning in 1938, when the first regulator was created, that the industry interest overrides most times the public interest. And so that's one of the reasons behind all of this criticism. And by the way, we should point out that Laurie Pusher, who is the CEO then, I think he's leaving now, or maybe has already
I
left.
think April 2025, so he's still in for a couple months.
Okay, but when he appeared before the House of Commons committee, I read his testimony, and he's very defensive. And the AER is absolutely determined to defend its actions and how it responded, when it responded, how it responded, the way it communicated with the First Nations. Like it's not saying, "Oh, we neglected to contact you as well." It's saying the company it was their responsibility, and they should have contacted you. And so the AER has been pushing off any kind of, it doesn't want to bear any responsibility for the issues that we've just been talking about. And I'll make my prediction now. I really don't see that. I would bet that they don't change the regulations because it would draw too much attention to what they've been doing, and they don't really want to talk about.
Uh, yeah, the interesting possibilities coming for tailing regulations is through the federal government because they control the limit on how tailings water could be released back into how much it would have to be treated to be released back into rivers. There was earlier promises by industry that they wouldn't be doing that at any point and that wouldn't be necessary. Now industry is saying that it definitely is necessary, and now they're arguing that that's environmentally protective because if they're not able to release the water, the tailings ponds are going to become too full, and that's riskier than just slowly pouring them back out. Uh, the federal liberals who are still in power for a while longer here have sat on that issue and not made any decisions or done anything really for a long time. There's a related regulation for coal effluent, which is incredibly important on the coal issue in Alberta, which is not what we're discussing today, but same thing. The Liberals just sat on it for, I think, 7 years. They were discussing doing something with it and nothing came.
I want to point out I've done some interviews with experts about the release of water into the Athabasca River and its tributaries. And the issue, an engineering professor at the University of Alberta told me, he said, we know how to filter this water. We can take a lot of maybe all of the heavy metals and the other problematic chemicals out of it. We can do that. Other experts have said, okay, but we don't. every tailings pond is different. We don't know quite enough about the chemical composition of those tailings. That's still an area that needs a lot of research and needs to be understood greatly. The third issue, which is the biggest one, is no one knows what will be the effect of releasing treated effluent uh, or wastewater into the marine ecosystem. That's an entirely open question. And the scientists I've talked to have said we need to do a lot more research so that if that water is released, we can say with confidence what the effect will be or won't be. And so there are, of those three areas, the only one we seem confident about is the middle one, the filtration and treatment. And on the composition of the chemical composition of the tailings and its effect when it's released into the ecosystem, big knowledge gaps. And so you can see why the industry is pushing because it's got a technical problem with its tailings pond, but the First Nations are adamant that that won't happen. So there's political issues and there are science issues. This is a snarled up mess, if ever there was one.
Yeah. And the question of the regulations under the Fisheries Act for water release is not exactly an issue of will the water release be allowed or will it not, but what level of contamination can remain when the water is released. And industry is going to argue that, pretty high levels of contaminants aren't a problem. And everybody who lives downstream and environmentalists and anyone else who doesn't enjoy drinking heavy metals is going to say, well, we want those levels much, much lower. So it gets into an argument about specific chemical contamination levels, contaminant by contaminant.
And we should also point out that the Northwest Territories, which is downstream of the projects, was really upset with the Alberta government because they didn't get notification. They have an agreement. I forget the name of the agreement, but the territory and the province have an agreement about this issue, and they are supposed to communicate. Alberta is supposed to communicate with the territories when incidents like this happen. They didn't, and the minister was pretty upset about it. And they patch things up a little bit, but I would imagine the territories is going to be watching this process with great interest.
Yes, because they're not interested in having contaminated water, contaminated to any level, poured through their territories.
I don't I think we've covered a lot of ground here, Drew, and provided a fairly good explanation of what the issues are and where the process is headed and so on. Can you maybe just we'll wrap up the interview if you can give us an idea of how the criminal charges will proceed through the courts and what kind of a timeline we're looking at?
Uh, well, I can tell you what the first step will be on February 26th. Imperial will plead guilty, they will plead not guilty, or they will seek an adjournment and ask for more time to negotiate something with prosecutors. If they plead guilty, then there's not much of a trial, and it will turn into an argument about the amount of the penalty, which I would expect will be negotiated out behind closed doors between the AER, the prosecutors, and Imperial. It's an open question whether that discussion would ever become public. The discussion that led to the Syncrude penalty, I have a freedom of information case going to court later this year to see if that can ever be made public, because they are taking the position now that it's secret forever. And actually, under Bill 34, it might necessarily be secret. So we might never find out how they decide the amount. If Imperial pleads not guilty, their core argument is likely to be due diligence, an argument that even though this happened, because of course the water did get out, everybody can see that, that there's nothing they reasonably could have done to stop it, that they performed all necessary due diligence to contain the wastewater on site, and that this was an inevitable accident, not their fault. The due diligence argument is available to them on all 9 charges. That was also an issue at Syncrude before the Syncrude 2008 conviction. And if they seek an adjournment, then nothing will happen for months longer. How long will the overall process take? I have no idea. It can run years in some cases. I
Well,
think that was all your questions. So yeah, probably slow, and that's what's going to happen next.
okay. How long did it take from the time that the ducts were contaminated in the Syncrude incident and the settlement was reached?
So I don't, on my notes, I didn't mark down months, only years, but it was about 2 years from when the incident occurred to after they had their trial and then entered the negotiated final penalty. So
Is that a reasonable benchmark here?
yeah, yeah. I think unless Imperial is in a big hurry to negotiate and conclude and everything wraps up really fast, I think we'd be looking uh, at least a year. We'll hear the end of this sometime in 2026, I think.
Well, Drew, thank you very much for this. Really appreciate it. And I have absolutely no doubt that we'll have you on the show again because these issues keep cropping up, whether it's other tailings ponds, whether it's conventional oil, it's a never-ending problem.
Yeah, yeah. There's who knows what bizarre nightmare will bring me back on this show, but it'll be soon.
Oh, goodness. Now you're going to keep me up at night worrying about that. Okay, thank you very much.
All right. It's great talking to you. Take it easy.